Hello, and welcome to the video lecture on Chapter 4. So we're going to cover civil liberties in this video lecture. These are usually 15 to 18 minutes, and it covers the study guide points and a few other things as well. Here's our to-do list. We have a discussion board and assignment, discussion board 4 and assignment 3. Here's our learning objectives. The essay is about civil liberties and burning the American flag, Texas v. Johnson. And it's about, I like to make things local, it's about the RNC, where 17 people were arrested. So kind of dig into that one. Discussion board number 4, privacy issues, technology, how does that play in? And assignment number 3 has to do with this young man and some school violence. So here we go. Civil liberties, it is a very careful balancing act. We believe in individualism in this country, and when do those individual rights and freedoms conflict with each other or conflict with the government? So, we lean towards the individual in this society. We want to be able to make private decisions, make personal decisions. More of the socialist ideology, either in economy or in government, tends to lead more towards the good of the whole. So the book talks about Sandy Hook, which was a national shooting. And so the study guide is asking about what is the area. Sandy Hook is a sad, really heart-rending time in America's country, December 14, 2012, and has to do with school shootings. Civil liberties versus civil rights. So civil liberties are those things that individuals have, and they are typically in the Bill of Rights that people have. And as individuals, I have these rights. Again, citizens have rights. Civil rights is more about the groups' collective decision, especially minorities after the Civil War with Amendment 15, 16, 19, and then eventually 26, the Voting Rights Act, and being able to participate because you've been singled out or treated differently as a group. Chapter 4 is on civil liberties, and Chapter 5 is on civil rights. So the transformation of the Bill of Rights, basically the Bill of Rights was a national thing. The right to bear arms, the Establishment Clause was all about the national government. But after the Civil War and the 14th Amendment in 1868, which says that no state shall deprive someone of their life, liberty, or property without the due process of law, that got us into incorporating the Bill of Rights, is the verb that we use, and then the Bill of Rights being applied to state and state court systems and state life. Early civil liberties have to do with things like habeas corpus, which is the right of someone. It's called, habeas corpus means bring the body forward, which means if you're in prison, you can't be in prison for a long period of time. You have the right to bring them to a judge and find out what's going on. 2 study guide questions. Ex post facto. Ex post facto is Latin for after the fact. You can't bet on a horse race after the horses have finished the race. You cannot make a law declaring something illegal and apply it to events that occurred before the law was passed. If it was legal when you did it, it stays legal. If you do it after the law has been occurred, then whether you know about the law or not, ignorance is no excuse, then you can be. So ex post facto. And Bill of Attainder are typically specific laws targeted to people. So in those days, if the king, or in this case a legislature, did not like someone, they could write a Bill of Attainder that, and I think I might say something kind of funnish like, well, the state of Ohio passes a law that people with red hair can be held in prison for up to a year without any trial because there's a certain couple of redheads that we don't like. We want to put them in jail. So that's kind of a Bill of Attainder. So in selective incorporation, originally we applied some across the country little by little, and then over time a more holistic interpretation. Let's look at the First Amendment, which has several things in it, and one of them is religion. So the Establishment Clause. Government, and the national government, and then eventually the states when it got incorporated, may not create or support an official state religion. Needs to be a neutral third party. Now, Separationists, there's a whole group of people behind Thomas Jefferson's thinking in a letter he writes to a friend that there should be a, quote, wall of separation, unquote, between church and state. The accommodationists believe that the states can't show preference. And the Supreme Court has been on both sides of that issue. They are more accommodationist today. Free exercise, that people can express themselves and their religion freely. And then if government wants to impede on that, and this had to do with employment law in the 1950s, I think, had to do with Seventh-day Adventists being asked to work on a Saturday. Did that step on their religious freedom? The answer finally became to compelling state interest. If there's a compelling state interest, that's fine. If not, it's okay. Basically, the court leaned that it was a violation to ask a Seventh-day Adventist to work on Saturday, and then eventually kind of got away from that in a 1990 decision and said that, no, it's okay. If someone doesn't want that job because it's a Saturday job, they can find another job, I think is the way it worked out. Free speech and expression, clear and present danger, fighting words. So I talked about the burning of the flag as the essay question. Okay, if I go to my basement and I burn my flag and put it up on Facebook, do I have the right to do that? Yes. Am I standing in an incendiary crowd of high tension during the Republican National Convention and start to burn a flag? I think that's a very dangerous situation, and so arrests are going to occur. So here I mentioned the Women's March on January 21st, and then the March for Life on January 27th. So this is the right to assemble freely. Women's March day after, the Saturday after the inauguration on the 20th. The March for Life the following Friday, the week after the inauguration. The one on the left is from the news. The one on the right, I took those pictures from the African American Museum and listened a little. Vice President Pence spoke that day. So whether left or right, and I think I have these on the left and right, as a matter of fact, we have the right to say, you may not agree with it, but we have the right to peacefully assemble. Number 53, sedition. So what if someone says, and right after the election, Madonna said she wants to blow up the White House? Well, technically that's sedition. I think it's more applied in, today terrorism would be more involved. So if someone were to get to say, that the Middle East, and there are certain countries in the Middle East, and they're fomenting this trouble, and we need to do something about these people from the Middle East, is that, are we violating religious freedom because we're naming Muslims? Or is this sedition? The people from the Middle East are blowing up the government, so when they protest, we need to arrest them. But sedition is speech inciting people to rebel against the government. Political correctness, number 55, is an expression that is perceived to exclude or marginalize or insult groups of people. And it's interesting, a lot of debate on this one. Political correctness is one of those eye of the beholder kind of issues. So if you're more on the liberal side, you feel political correctness needs to be embedded in the culture. If you're more on the conservative side, you feel that the liberals' agenda is being pushed on your privacy. Political correctness was very hot for a long time. I think it's cooled down a little bit more. Prior restraint is the judicial suppression of material to be published or broadcast. So it was created and targeted against freedom of the press. And there was an Alien in Sedition Act passed in I think it was 98. You can fact check me on that one, I might not have the right date. But it was the heartbeat of election in the 1800s when Thomas Jefferson ran for presidency, that John Adams was arresting newspaper people as part of the Alien and Sedition Acts for criticizing him. Whereas today we would just call that a press that leaned a little to the left or the right. It might be the New York Times or it could be Fox News. Obscenity is an area where we have struggled as a country. We talk about one man's vulgarity as another man's lyric. Exceptions have been made. So the Miller test, number 54, if the work taken as a whole lacks any redeeming social value. And this was a community in California, it's Miller v. California, and that test, this kind of redeeming social value test, is what eventually became the landmark decision for the obscenity area. And this has a lot to do with movies and other things that are maybe a little bit more graphic. The right to bear arms, one that is very strongly held. Tea Party people really kind of grabbed to this one. A lot of the voters in the election particularly grabbed to it. So that's the Second Amendment. Criminal rights in the Constitution, so 1, 2, a little bit of 3, more on the civil side, more on the criminal side, so civil liberties applies to both liberties of the person to be and then criminal rights when in a courtroom. Here's the Fourth Amendment, protection from unreasonable search and seizures. The exclusionary rule, number 58, is Supreme Court decisioning says that illegal obtained evidence cannot be used in a court of law. And that's a basic part. It's excluded. That's the exclusionary rule. Now, the court has tempered that judgment. So today, for example, if evidence was obtained due to unintentional, like the wrong address was on the search warrant, but they went to the right house, or the police made a good faith, that's words used a lot, they made a good faith attempt at something and might have inadvertently violated a procedure, the evidence can still be used. So we're more in an accommodating mode under the exclusionary rule. Fifth Amendment, grand jury. Sixth Amendment, trial by jury, right to counsel. I've done a lot of work in the right to counsel. We can talk about that in the class sometime. Seventh Amendment, trial by jury. In the civil case, again, civil is a case against an individual harming you. Criminal is where you've done something against the whole society. So a murder is both a crime and a tort. That is, a murder can be prosecuted in a criminal court and you can go to jail, and then you can be sued in civil court as a tort and pay money. And the O.J. Simpson case is one of those that was tried both in criminal and civil courts. Due process of law, number 57, says that you cannot deny someone their due process of law. The laws must be reasonable and fair. Those who are accused of law breaking have these rights. If you violate those rights, then they might have had actus rei, the guilty act. They might have had mens rea, the guilty mind. But if due process was not followed, they will walk because we believe the due process of law is more important than putting somebody behind bars. Death penalty is one that we had, that's the Eighth Amendment in cruel and unusual punishment. You know, we've outlawed some modes of punishment as cruel and unusual. Many people feel that any death penalty, and we're one of the few quote unquote civilized countries that still uses the death penalty, but it comes from our political culture, particularly the kind of the development of the West and the gun culture that we have in our society. So certain forms, like you cannot crucify somebody today, but you can use death by lethal injection today. And occasionally, like the bomber for Oklahoma City, he was asked a federal death sentence. He was asked to be shot, firing squad. Constitutional right to privacy is very interesting. We are high on individual rights, high on privacy, far more so than other countries. So where is that line? And that constitutional privacy comes out of the First, Third, Fourth, Ninth, and 14th Amendments. So we have a lot in the Constitution about privacy, and we believe in it strongly. So we have many movies about that, like Enemy of the State, which is one that it's an early Will Smith movie about where, you know, the government is everywhere, and that has played out today. We have drones, which actually kind of, a celebration that had drones with colors, and it's used at Disney World at Christmas time. Yeah, but if that drone's peeking in your bedroom, that's a whole other thing. Conception, abortion, and death. So Roe v. Wade, I don't want to take those lightly, those are serious policy areas. So Roe v. Wade, 1973, number 59, a Texas law making it a crime to assist a woman to get an abortion, was the heart of the abortion decision, which permitted more abortions in this country. Been a ton of pushback on that one, but it's been around since 73. So it's going to be hard. Conservatives still talk about getting judges to overturn it. So that would be an interesting one. Now, right to die, number 60, that's allowing a physician to assist with someone who's terminally ill. So voluntary self-administration of lethal injection or physician-assisted suicide would be another way. But the right to die has to do with a right to be able to end one's life if one wanted to, and typically is seriously ill. So we are accustomed to think about citizenship as a status, but it does have its obligations. And I think in this country, because we have so many rights and that we are far more individualistic, I think we surprise other societies. What we take, I don't say for granted, but we just take it as part of the culture, is not so much part of the culture in other parts of the world. Here is the Bill of Rights, key court cases about them. I won't go over all of them, but the one I've written about, counsel and felony cases, Gideon v. Wainwright, where a young man, not so a middle-aged person, was accused of stealing some beer, wine, and Coke out of a grocery store. It was his third felony, so he was sent to prison, I believe, for life. He had no attorney and eventually wrote a hand petition to the Supreme Court, and eventually the decision became Gideon v. Wainwright, which set up the public defender system in this country. If you're accused of a felony and you're going to go away for more than a year in jail, then you have the right to have counsel with you at all times. Here's the Bill of Rights, a little bit about from the beginning, things where the Constitution was brought from, the coming in with police and smashing up the press of a printing press, militia coming to your house and committing crimes against you, quartering of soldiers, the arrest of search and seizure without a warrant, right, for example, the right to an attorney because, the right to be accused of what is wrong. The one, number 6, the attorney, you could have an attorney and the attorney wasn't allowed in the room. Jury trial in civil cases because judges are appointed by certain people for life and therefore they can just decide anything they want. Cruel and unusual punishment, that would be things like quartering, crucifixion. Rights are kept by the people and the states. So 9 and 10 has to do with keeping rights that aren't expressly written in the Constitution. So I'm giving you a flavor for what was in the people's minds when they wrote the Bill of Rights. It was very much about the colonists and how they were treated. And we're interpreting it now, 200 plus years later in a modern society. So it moves and breathes into that new society, but how much do we veer from framer intent? The new Supreme Court Justice nominee, that's a person who believes, called an originist, would stick more to what framers meant as opposed to ultimately someone, Earl Warren, who was actually appointed by Eisenhower and was from a Republican, but a little more on the judicial active side that says the document must breathe, our interpretation of the government must breathe to match. All right, that's all I've got. I hope this has been helpful to you and in your preparation for our first test.